All right, pause. Reyes just waived both her right to a trial and her right to appeal. That's not just a legal move, that's a power play, or a sign of serious negotiation behind closed doors. So what pushed this case into fast forward? Let's rewind and dissect this legal chess match.
5-year sentence.
And I'll walk you through the paperwork.
Correct, Judge.
All right, the court is calling 2024 CR 01309 and 2025 CR 000240, State versus Allison Settle. Can I have parties announce?
Will Brooks for the defendant, Ms. Settle, Judge.
And are you Ms. Settle?
And
Counsel, have you received all discovery in each of these cause numbers? Did you review them with your client?
Yes and yes, Judge.
In each cause number, the court will find that the state is in compliance with discovery. Ms. Settle, did you review the documents entitled Application for Deferred Adjudication with your attorney? Did you understand it and sign it? Did you review the true bill of indictment in each of these cause numbers with your attorney? Did you understand it?
yes, sir.
Counsel, do you waive the reading of the indictments?
We do, Judge.
All right. And cause number 2024 CR 013090. It appears state that you're proceeding on count 1, you're waiving count 2 in the repeater enhancement allegation. Is that correct?
That's correct, Judge, and that should be the case for both causes.
All right. Any objection?
No objection, Judge.
Quick legal decode. This is a third-degree felony with a potential 10-year prison stretch. But notice how the judge brings up deferred adjudication, a legal gray zone where you can avoid a conviction if you walk the tightrope perfectly. Miss a step? That 10-year sentence comes crashing down like a hammer.
And each cause number, did you see the court review the court's admonishments with your attorney? Did you understand it?
Yes, sir.
And did you sign it in all the appropriate places?
I did.
And the cause number ending in 90, you're charged with unlawful possession of a firearm by a felon as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If I grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could sentence you up to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, sir.
And the cause number ending in 40, you're charged with fraudulent use or possession of identifying information, 5 items to 10 items of the elderly as a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, sir.
And each of the cause numbers, if you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. Off the record. Deputy Lord, could you make sure they bring out Miss Chelsea? All right, we're back on the record. Did you understand by entering these pleas, you were giving up those rights?
Yes, sir.
And did you intend to give up those rights and enter into a plea in each of these cause numbers? Counsel, has anyone threatened, counsel, has your client been able to provide with any defenses?
She has, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Judge.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Concurrent sentencing. Key term. That means if she's sentenced to time, both charges run together, not stacked. Think of it like watching 2 bad movies at once instead of one after the other. Better outcome, but still not ideal. If prison's on the table...
Ms. Settle, has anyone threatened you, coerced you, or placed you in fear to get you to enter these pleas?
No, sir.
Anyone promised you anything other than the plea bargain agreement?
No.
Are you satisfied with the way you've been represented?
Yes, sir.
Are you a U.S. citizen?
Thank you.
Court will find that this defendant has knowingly and voluntarily waived her right to jury trial in each cause. In each cause that you review the plea bargain page with your attorney, did you understand it?
Yes, sir.
In each cause, the state is proceeding on count 1 and waiving count 2 in the repeater enhancement allegation. They're asking that your punishment be assessed at a cap of 6 years in the prison. There's a $1,000 fine. The state is opposed to your application for deferred adjudication or community supervision. The cause numbers will run concurrently. And the cause number ending in 90, you're to follow conditions listed under 2025 CR 00240. And in that cause number, there's to be no harmful or injurious contact with the complainant and family. There's to be no contact with Vargas, Thurston, Uriga, Getz, and Creamer. Did you understand that to be the plea?
Yes,
I'm
ma'am.
sorry, but that's the way I said. It's Creamer, Creamer. Is that how you pronounce it?
It is, Judge.
Is it Creamer? I think it's Creamer.
Richard Creamer, Judge.
Thank you. Okay.
Dr.
All right.
Dr. Richard Creamer.
Just a second. All right, so we're back on the record. Did you understand that to be the plea in each of these cause numbers?
Yes, sir.
Defense?
Yes, Judge.
State?
Yes, Judge.
All right, did you review the waiver of appeal paragraph in each of these cause numbers with your attorney? Did you understand it and sign it in each place?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, are there any such motions?
Motions, I think we had rulings on a bond motion, but otherwise no other rulings, Judge.
And the cause number ending in 40 outside the agreement, they're asking that you have no contact with Rudy Rodriguez. Did you understand that was a recommendation from the state and the court does not have to follow that recommendation?
Yes, sir.
Then in cause number 2024 CR 013090, how do you plead to the offense in count one? Guilty, not guilty, or no contest?
No contest.
And in cause number 2025 CR 000240, how do you plead to count one?
No contest.
No live testimony today. That's huge. The evidence is all on paper. No dramatic cross-examinations, no surprise witness meltdowns. This is a bench plea with the judge reviewing reports and exhibits. But don't confuse the lack of courtroom drama with leniency. Judges weigh everything in writing just as heavily.
All right, state any evidence to support the defendant's plea?
States with attachments in each cause, Judge.
No objections to states one or attachments in either cause, Judge.
All right, in each cause number, did you review the documents entitled waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachment in each cause number, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding of guilt as you've applied for deferred adjudication. All right, we can go off the record. So they're telling me it's taking about 8 weeks for PSI to be done. So we can do the 8 weeks, or if you would like, I could set it sooner and you can have witnesses come in and testify. Which do you prefer?
Judge, I think a PSI needs to be done. I think more important would be a screening for drug court, Judge, and then a McMyoff evaluation as well.
All right, so in each cause number, I will request then the PSI, a TAP evaluation, McMyoff evaluation, and a referral to felony drug court. Norma, what date?
July 28th.
All right, we'll come back on July 28th. And at that time, I'll make a decision on your application. You need to make sure that you make all of your appointments. Normally, you will have an appointment that you meet with a probation officer. These other appointments, they're completely separate, so you'll be given completely different days for them. All right, is there anything else?
Judge, if I may, she is currently on.
Now we pivot from law to life. This isn't just a defendant. She's a new mom under house arrest, juggling a GPS monitor, a child, and a legal tightrope. The system doesn't always account for motherhood. which makes this next moment complicated.
So she's got a GPS device, Judge. We've had some modifications in the past. Currently, she's living at Haven, and she's getting services there. She's a new mother, and she has possession of the child. There's a ton of appointments and things she has to go through, both for services and then for the baby. The challenge has been asking her officer and her officer coordinating all the different things she has to go to. Become cumbersome for the officer as well. That's the court to consider switching possibly to tracking. A lot of times I think we'll have full house arrest. We're concerned about protecting victims, concerned about the person fleeing, but she's demonstrated a propensity to show up to court, and she knows what the restrictions are in respect to some of the complaints are strange, but in respect to her family, Judge.
All right, and where's the child right now?
My mother is watching her one of them.
Yeah. Mother's one of the complainants, Judge.
Okay.
But she knows not to bring a child to your court. That's why she was.
No, I mean, I'm always concerned if yes, do not bring children to court. But if you're not, I'm hopeful that they're in a place that's safe.
Absolutely.
All right, State, what do you say? So this is through pretrial?
Yes, Your Honor.
All right, who's the pretrial officer?
Genesis Ramirez.
All right, Ms. Ferguson, you have Genesis Ramirez zoom in, please.
Ramirez?
Yes. I just have to see, we're going to have your pretrial service officer zoom in. So, there you are.
Hello, good afternoon.
Hi, good afternoon. Thank you so much for zooming in. It's on Miss Settle, Allison
Yes.
Settle. All right, so defense is saying that she has a lot of appointments that she has to attend. What appointments would those be, defense?
Mostly doctors, stuff for my daughter, and then housing.
All right, so the doctor's appointment. I'm assuming that there will be no issues with doctor's appointments. Officer Ramirez?
Oh, yeah, sorry. No, there's no issues. And she's been very good as well with communicating with me. Every time she has appointments, she makes sure that she emails me 24 hours ahead of time. And then she's also really amazing at providing me every doctor's note. Every time she goes to the hospital, every time she goes to the doctor, she always provides all her doctor's notes, and I have all those as well.
All right, so there's no problem with her going to the doctors?
No problem at all. Yeah.
I think it's just the process, Judge. That's why I was asking. So, Officer Ramirez, I was asking the court today to consider alternate amending to tracking only.
Oh, that's a sobering moment. The judge is drawing from real experience. Removing strict monitoring too soon can lead to relapse, especially when addiction's part of the story. It's not just about rules. It's about accountability, structure, and giving someone just enough freedom without setting them up to fail.
Okay.
And would that be easier for you? In other words, is it a pain to log the requests and the...
I mean, I wouldn't say it's a pain, but it is a lot because I know Miss Allison has had a lot of appointments. I know with her baby, she's been going to the doctor a lot recently. And so, I mean, I have also told her to try to file that motion to either tracking only or to get the GPS removed. So that way it can make it easier on her. You know, we always say, like, if it's an emergency, you can go no matter what. Just make sure you provide the paperwork stating you were there. But yes, it would make it a lot easier that way. You know, she can come and go to the hospital as she pleases.
Thank you, officer.
Mm-hmm.
All right, thank you. So here's my issue. What I've discovered is when you have people who have addiction issues, everything is going great because they're being held accountable for every single thing that they do. But then when you say, oh, we're just going to do tracking only, then people start backsliding. And I don't want that to happen. And that is my concern.
Understood. All we can do is make the request, Judge.
So I don't know, State?
I appreciate that she's been a compliant, Judge. I'm not vehemently opposed to her request for tracking only. If this court is inclined to grant tracking only, I would just ask that she abide by the no harmful and injurious contacts and no contacts listed in the plea agreement.
All right. Well, I tell you what, I'll do tracking, but it'll be tracking with a curfew.
Judge, I think that's fine.
So if y'all want to figure out a curfew time, y'all can figure out a curfew time.
If not, I think it's 19. But I'm usually in by 6 and the baby goes to sleep by 7. Oh, in the morning, 8.
It would do 8 to 6, Judge, or 8 to 5.
All right. So, State, what do you say to 8 to 6 p.m.?
Agreeable, Judge.
All right. So she has tracking, but she can be out and about from 8 a.m. to 6 p.m.
Thank you, Judge.
Thank
All
you.
right. Thank you.
Thank you, Judge.
Appreciate it. May we be excused?
Thank you,
Yes.
Ms. Ramita.
You all may need to do an order because they'll have to put in the order and we'll do it. But it starts today.
Thank you, Judge.
Thank you.
You're welcome. All right. Thanks.
Thank you.
You, officer.
Thank you so much for
All right.
zooming in.
Bye-bye. You're welcome. Bye-bye.